A neighbor calls the police on you for a welfare check. Before you know it, your door is kicked off the hinges and you're in handcuffs. It's a legal loophole that police are using to get inside your home without a warrant. But a unanimous Supreme Court ruling gives you the power to stop them. Let's imagine a scenario. You have a minor argument with your neighbor about a tree branch hanging over your property line. No threats, no violence. You make your point and you go back inside your house to cool off. But your neighbor is vindictive. He calls 911. He doesn't say you committed the crime, but he says you seem really agitated and that he's worried about you. And he asks the police to do a welfare check. Minutes later, the cops are walking up to your front door. Now, the police have a right to do what's called a knock and talk. But to do it, they have to enter the curtilage of your home. That's your porch, your walkway, the area immediately surrounding your house. Legally, this space has the same Fourth Amendment protections as your living room. The Supreme Court says police have an implied license to be there. It's the same license as a pizza delivery guy or a Girl Scout selling cookies. They can knock and state their business, but the moment it's clear you don't want them to be there or don't want to talk, that license is gone, and they must leave your property. In our story, you see the police, but you know you've done nothing wrong, so you simply don't answer the door. Smart move. You are exercising your right to be left alone, but the police don't leave. They keep knocking, and they call back your neighbor for more information. The neighbor, wanting to cause more trouble, tells them, I think he takes medication for anxiety. Maybe he had a bad reaction, can't get to the door. For the officers, this is the pretext they've been waiting for. They now decide they have a reason to force entry, not for a crime, but for a medical emergency they just invented, all under the guise of the community caretaking function. But the law demands a true emergency. So what qualifies as a true emergency, or what the law calls an exigent circumstance? Courts have defined a few specific examples. The first is the most obvious: imminent danger. This means police officers can hear cries for help, the sounds of a violent struggle, or even gunshots coming from inside the house. They have a duty to go in and protect life. Second, the destruction of evidence. Now, this is a high bar. Police must have probable cause to believe a serious crime has occurred, and then they have to hear something that indicates evidence is actively being destroyed, like toilets being flushed constantly or a shredder being run nonstop. The third is hot pursuit. If they're actively chasing a fleeing villain that runs into a home, well, they can follow that person into the house to make an arrest. A true medical emergency also counts, but it has to be based on credible first-hand information, like someone from inside calling 911 for help, not some sort of vague second-hand information from an angry neighbor. So the police kicking their door, and they find you on your couch, watching TV, perfectly fine. There was no emergency. You're startled. You're furious. You yell at them to get out of your house. To justify their bad entry, the officers now claim that you're being aggressive. They grab you and arrest you for disorderly conduct, maybe even sprinkle in a little resisting law enforcement. So what happens now? In a real federal case almost identical to this, a city taxpayers had to pay over $750,000 because the court found the officers' actions were a blatant violation of the Fourth Amendment. This is because of the landmark Supreme Court case Caniglia versus Strom. The court ruled unanimously that the community caretaker excuse does not apply to the home. The constitutional protections of your home are absolute, short of a warrant or one of those true, provable emergencies we already discussed. So knowing all this, how do you protect yourself? Rule number one, keep your door shut. If you open your door, anything the police see inside is subject to a plain view doctrine and can be used against you. Do not give the police an excuse to see something to justify their entry into your home. Rule number two, if you feel you must engage with the police, speak through the locked door. State clearly, I am fine and I do not need help. I do not consent to any searches. You do not have my permission to be on my property. Just like that. Now, some officers are going to say, I can't hear you. Can you open the door? Don't fall for that. I've seen that. Rule number three, record everything. Your Ring camera or your cell phone is your number one witness. It proves there's no emergency and that you clearly told them to leave, revoking their license to be there. Now listen, if you've watched this long, please subscribe and leave me a comment. I don't even care what the comment is. Mark, you're terrible. Mark, you're awesome. I would appreciate a comment. I'm going to try my best to respond to all comments, although I cannot promise that I get a lot of comments. I got a lot of stuff going on. If you're facing a criminal charge in Indiana and you need a team that will fight for your constitutional rights, call me at the Marc Lopez Law Firm, 317-632-3642. We will fight for you. We will fight for your rights. But most importantly, remember to always plead the fifth.